Hello, my name is Mike Tessera and I prepared this cheat sheet for June 2024. And as you may know, if you've been watching these things previously, is that what I seek to do is summarise all the ACCC goings on for a particular month. So this month I'll be looking at June 2024, and I'm a bit behind. I've been very busy. I've recently been appointed to NCAT as a general member, and I had a lot of work over the school holiday, so I fell a bit behind in this area. But hopefully, I'll be able to catch up in the next week or so and do July and be back on track. A bit of background myself. I've been a competition consumer lawyer for over 30 years. In the last 17 years, I run my own legal practice, Associated Consulting, and I help individuals and companies with competition and consumer law matters. Also do a bit of expert consultancy work for legal publishers such as LexisNexis, CCH, Walters Kluwer on competition and consumer law. Prior to that, I worked at the ACCC for 15 years, and I worked as Director of Enforcement, and I was also Director in charge of the Sydney Emergency Asset Sales Branch, and had some other roles as well. Now, the outline's pretty straightforward. 1 court case, 2 enforcement actions, 3 mergers, the release of the ACCC's 2024-2025 product safety priorities, inquiries and consultations about 4 of those, and 2 other matters. Now, the main case, or the only case, came down in June was ACCC and Delta Building Automation, and this was an allegation that the company had sought to enter into a price fixing and bid rigging arrangement with its competitor in relation to a tender for the National Gallery of Australia. And I'll disclose here I have an interest in this case. I've been hired by Delta to assist it in its compliance program. And I'm also put evidence on in this penalty hearing about what I'd done, I guess primarily to show that the need for specific deterrence was less than may be the case otherwise. So the ACCC was seeking a penalty of $2.5 million against the company, which is about 25% of the maximum $10 million penalty, and also $150,000 against the managing director, which I think at the time it was a $500,000 maximum, so it's about 30%. And then the court actually ordered $1.5 million against Delta, which I think is pretty good, knocking off $1 million off the price, the amount sought by the ACCC, and the fine imposed against the managing director didn't go down very much, $120,000. And it all rose from a very short meeting that happened in the Canberra Cafe back in December 2019, where it's alleged the managing director of Delta put a proposition to his competitor about the way the tender was going to work for the National Gallery, and that was rebuffed immediately. So it was an attempt to induce a price fix. Now, when the Bromwich was weighing up the various factors that were relevant to penalty, he looked at the following issues specifically. Firstly, that the target of the alleged bid rigging activity was a public body, the National Gallery of Australia. So the implication there would have been that if it had been successful, the public ultimately would have paid more money, more public money would have been spent to get these particular services. He also found the company had or did not have an effective culture of compliance at the time the contract was engaged in. A factor that resulted in the penalty coming down a bit was the size of Delta, and there's quite a lot of exploration of the way the company operates, but also in relation to the personal penalty, looking at the trust arrangements that the managing director had in place. Also, Bromwich concluded that when considering the benefit to arise from the conduct, it's not a question of looking at the profit, it's a question of looking at the revenue. So that's a very significant approach which the courts are required to take nowadays, following a High Court case last year involving some bribery offences that occurred offshore. He also thought that it was relevant to, I guess, give a bit of a loading to the fact that it involved a prestigious contract. So clearly trying to win a prestigious contract adds to a company's credibility in the market. So that was relevant. And finally, the involvement of senior management. As I said, I helped the company with the compliance program. I also put in affidavit evidence for the penalty hearing. As you can see, the compliance training and the various policies were designed by me and implemented by me in the company. And so, as you see there, they used an external specialist in competition law, formerly a senior investigations official at the ACCC. And it was also observed a about the weight to be provided to the compliance steps that have been implemented by the company. So as the conduct was denied and defended at trial, as was the respondent's right, necessarily there is an absence of mitigating contrition as relevant to the extent of the need for deterrence. So effectively, you're going to fight the case. You can't at the same time be saying, I'm sorry for what I did. That doesn't sort of work. But their position was ameliorated to some extent by the implementation of a training, compliance and complaints program conducted, I love this bit, by a respected former senior official at the ACCC. So apparently I was respected. I didn't feel like I was respected when I was there, but anyway, these characteristics do give rise to a real and substantial need for general deterrence and a lesser need for specific deterrence, although specific deterrence remains relevant and important to reduce the residual risk of recurrence. So what he's saying there effectively is that the fact that they implemented this compliance program with training from a respected former senior official had an impact on deterrence, and obviously penalty is a way of achieving deterrence. So this all plays into the calculation of the penalty and how large it needs to be. So he concluded, Robert Bromwich, that while the contraventions did occur in the context of there not being an apparent culture of compliance, I do consider that material steps have been taken to remedy this. So that's the implementation of a compliance program, policies, training, etc., and that this is likely to have a material effect on the risk of recurrence and therefore on the level of penalty needed for specific deterrence. Noting compliance orders are agreed to by the respondents, which will give weight to that consideration. It does not work, the penalty response in the future, the case is likely to be severe. So all these steps that the company took in relation to compliance has had a direct and tangible impact on the level of penalty. As you can see, the ACCC wanted 2.5, and the judge knocked $1 million off it, not entirely due to the compliance program, but that was a significant contributing factor to the reduced penalty. In terms of enforcement, the first one involved a place where actually my daughter used to work, Time Zone, but it's the owners of Time Zone, Kingpin and Zone Bolding, and they were hit with infringement notices. Each of them paid $49,500 in penalties due to selling various novelty products that did not comply with the button battery safety standard. And they were the world's smallest alarm clock, the pocket fart gun, and the sonic spinner. So really essential products for every young person to have. And MDI was a supply company which supplied the units to its various subsidiaries, 10,000 units, and then about 5,000 were on-sold to consumers. And the breach here was that they were sold without conducting the relevant testing prior to supply. So the obligation under the battery standard is to do some testing before you put the goods into circulation. And often the goods may actually comply, but you fall foul of the standard if you haven't tested them. And here are the three products: the world's smallest alarm clock, and don't really get a feeling for how small that is, but it is very small. The pocket fart gun, and you can actually try it before you buy there, which is very helpful, and the sonic spinner. Now, the second enforcement action involved Dodo, which is owned by M2 Energy Proprietary Limited. This is an interesting case. This is against some infringement notices, $82,500, and related to alleged breaches of the Electricity Retail Code of Conduct. So it's actually 6 infringement notices were issued, and it was all done by consent. So Dodo admitted that between those dates, the standing offer prices for 2 of its offers exceeded the relevant cap in force at the time. That's a breach of the code. Obviously an oversight. That wouldn't be something you'd be doing intentionally. Dodo also admitted that it sent price change communication to customers on a particular date, between particular dates, which failed to include information required under the code, and it did not make a record of how it calculated some matters related to the offered prices required by the code. So these are all specific requirements under the code to provide more information to consumers, greater transparency. And it seems to me that there had a bit of a system failure, and that probably explains why the infringement notice is not litigation. Mergers have been really active in the last few months, and what I've noticed is ACCC is expressing a lot of concerns about various mergers, and I think most of them make sense to me. I think there's just a lot of very marginal mergers being put forward. Now, the Icon Group, which I hadn't really heard of before, but it's one of the largest providers of radiation oncology service in Australia, and it's proposed to acquire 3 leases: Ipswich Hotel, St Vincent's Private Hotel in Chermside, and St John of God in Geelong. And basically, when you look at the market in terms of the provision of radiation oncology services, Icon, the acquirer, and another company, Genesis Care, operate 94% of private radiation clinics in Australia. So that's a huge percentage. Admittedly, some of the private radiation clinics or public hospital type radiation clinics would be in the market as well, but it's likely to be a very highly concentrated market with high barriers to entry. Some of the equipment that you have to use in that particular area is very expensive. Now, the ACCC is concerned the proposed acquisition will entrench Icon's already strong market position and increase its ability to raise prices, reduce services. It identified 3 areas of particular concern: Geelong, Brisbane, and southeast Queensland, which isn't really great news for the company because they seem to be the 3 places, or 2 of the places where they want to buy these leases. So maybe Ipswich will be all right, but Geelong and Brisbane and southeast Queensland are all areas of concern. A key issue for the ACCC is the extent to which radiation oncology providers may experience economies of scale and scope in the relevant geographic areas. So if there's scale and scope economies, then the barriers to entry can be higher and the chance of new entry is going to be reduced. So see what happens there, but maybe it'll be a case of them not proceeding with at least 2 of those leases and maybe just proceeding with Ipswich. Sigma Healthcare's proposed acquisition of Chemist Warehouse sounds a bit anomalous to describe it that way because it really is a reverse takeover. It's Chemist Warehouse that is paying all the money to Sigma to effectively get a backdoor listing to the Australian Stock Exchange. And the ACCC said a lot of things about this merger, but I've got to say straight up, I don't ultimately think there's going to be any problems. Might be a small divestiture required, but I can't see it really reducing competition. It's going to stir up the market, it's going to change the dynamics in the market, but it's not a basis for opposing the merger. So they said in their press release and also statement of issues, it's a uniquely vertically integrated business across multiple levels of the pharmacy supply chain, which could raise barriers to rivals expanding or entering. So what you're going to have is you're going to have a major pharmaceutical wholesaler, Sigma Healthcare, integrated with Chemist Warehouse, but Chemist Warehouse is a franchise operation, so it's effectively integrating with Chemist Warehouse franchisor, which provides various services, wholesaling services to the various Chemist Warehouse retail outlets. But fundamentally, the supplier of at least pharmaceutical products and a lot of beauty type products and other those type of non-drug products is already Sigma. So there's going to be no real change in the wholesale arrangements between pre and post acquisition. The ACCC was also concerned the proposed acquisition may harm pharmacies currently supplied by Sigma, leading to SLC. So Sigma doesn't own pharmacies, Chemist Warehouse doesn't own pharmacies. They're all independently owned due to the very restrictive provisions of relevant pharmaceutical ownership or pharmacy ownership laws in each state. So what they're saying is that with the new entity, that there might be some discrimination against the Sigma supplied pharmacies such as Amcal and various groups like that. Why that would make sense to do, I don't quite understand. Economically, it wouldn't make sense for, I guess, a franchise or wholesaler operation to discriminate between downstream operators that it didn't own. How the newly merged company may have the ability and incentive to favour Chemist Warehouse stores or worsen terms to non-Chemist Warehouse banner groups, raising their costs and rendering them less competitive. same concern as just was raised, and again, not very economically rational to be favouring the one non-owned business over another non-owned business. May enable Chemist Warehouse to access and use commercially sensitive data relating to pharmacies supplied by Sigma in a way that damages competition. So again, why would the Chemist Warehouse franchise or wholesaler want to use information obtained from Sigma aligned pharmacists and give that information to Chemist Warehouse franchisees? Doesn't make sense. Again, these things I don't think are real concerns in economic sense, because fundamentally businesses, if they have power to less competition, they're going to do it. That's rational. But these don't seem very rational responses to me. May substantially lessen competition in pharmacy retailing, particularly reduce competition Chemist Warehouse and Sigma's banner stores impose on each other. Well, that's maybe a little bit more legitimate, but again, why would a Chemist Warehouse pull its punches when competing against a Sigma banner store group if there's other banner store groups who are getting their products from Symbion or the other player in the market, API? Why would they do that? If you pull your punches against Sigma, you're going to lose sales to other non-aligned or non-aligned pharmacies. So again, it doesn't make a whole lot of sense that they would do that. Could impact upstream markets for the supply of pharmacy retail products, affecting in particular suppliers' products to compete with Chemist Warehouse and Sigma's own label and private label products. So again, I don't understand how that could occur. So I'm just trying to think of what that's referring to, whether it's actually referring to beauty and other personal care products. That's what I was trying to think of, personal care products, and whether there's going to be reduction in competition there. Doesn't again make a whole lot of sense to me, because a lot of suppliers of those particular products are very large entities such as Unilever, Johnson & Johnson, people like that. So they would probably have ability to continue to supply those products, and the merger's not going to impact that. So I'm predicting pretty much this is going to get waved through with a green light, but I guess we'll wait and see. Maybe the ACCC will get some evidence that raises some concerns, which they'll be able to prove in court. Now, there was Olam Agri Holdings' proposed acquisition of Namoi, and this was on the heels of the Dreyfus interest in the same business. But it's fair to say that there was a lot more concerns about Olam than there was about Dreyfus, and they were concerned the proposed acquisition would be likely to substantiate the competition supply of cotton ginning services in the lower Namoi Valley in New South Wales, and the supply of cotton glassing services. So a very definite concern raised up front about the Namoi Valley. The proposed acquisition would reduce the number of competing ginning mill supplies in the lower Namoi Valley from 3 to 2. So Olam operates already 4 of the 5 cotton gins if the acquisition proceeds. So that's a big increase. Olam may be able to significantly reduce competition for cotton ginning services, resulting in high prices, and also concerns about the impact of the supply of cotton lint glassing services. It's hard to see that's a really high barrier to entry market. I think the cotton ginning is a whole different ballgame, but cotton lint glassing services you wouldn't think are super high tech. The proposed acquisition would provide Olam with the ability to negatively impact competing cotton merchants from acquiring and marketing cotton lint and cotton seed. I just don't quite understand how that would occur. And they are also investigating the impact of the proposed acquisition competition with the supply of cotton lint marketing and cotton warehousing services, as well as the risk of coordination in the cotton lint marketing market through Olam and Louis Dreyfus's company's common investment in Namoi Cotton Alliance. You see both Olam and Louis Dreyfus have expressed an interest in Namoi Cotton, and there's concerns about both of them, and I think they're probably I won't foreshadow next month, but it is resolved next month in July. But here it seems to me that there's a lot more concerns about Olam proceeding with this particular acquisition. The next matter was the product safety priorities for 2024, 2025. And I guess a lot of it was to be expected, but probably the main difference between previous years was particular focus on lithium-ion battery-powered products. So they're obviously a big concern. A lot of them are catching fire and burning down houses and things like that. So they're going to be looking at that as a product safety priority. And the question there is, are they looking at some sort of standard that needs to be implemented there to sort of provide better safety about those products? And also virtual reality products. So again, I'm not entirely sure what the concern there is going to be, but clearly there must have been some statistics about injuries occurring from virtual reality products. You see a lot of things on movies and TVs that people are getting a bit carried away and falling over various things in their houses. So again, there might be some guidance put out to exercise some caution when using these particular products. They're going to seek to better understand future product safety risks through engagement with key stakeholders. So obviously taking a more proactive approach to product safety, bolstering their capacities to identify emerging product safety issues quickly. So there might be, I guess, a reference to both lithium-ion and virtual reality products. So they're saying, well, these emerging issues that we need to be ahead of. Clearly focusing on protecting young people from unsafe products, and they've spoken about nursery products, including furniture, baby bottle, self-feeding device, infant sleep products. So they're looking at those specific types of products. They also refer to the new information standard toppling furniture, which came out, and there's a 12-month transition period. So after that, they're going to be jumping on people who don't comply with those obligations. And then they refer to the enforcement undertaking obtained from LG in relation to these solar storage batteries, which have faults and can overheat and catch fire without warning. Haven't been too many instances of that, but I guess if you've got one or two instances of that, that's enough to make it a high priority for product safety. Then inquiries and consultations. The first is fuel prices. They do these quarterly monitoring reports, and I guess they show that prices going up, prices going down, and explain the reasons. And I guess it's a good way of just creating some transparency, and companies are, forced not to increase prices opportunistically. Really, if there's a change in international pricing or some other factor, then obviously prices will go up. And if there's a oversupply internationally, then price should go down. So as you can see here, March quarter showed the prices in the 5 major capital cities have reduced by 1.7 cents per litre, and then they started going up again in April. So that was due to international refined petrol prices. And they also looked at diesel prices, so not just petrol, and they noticed that basically there'd been a decrease in the prices for diesel. And they do a lot more information, provide a lot more information in reports. It's just a summary document in the press release, but they do quite detailed reports showing difference between, city pricing and country pricing, and how the money's broken up between excise and other components of the price. Telecommunications report. The ACCC was looking at all the different industries that were subject to declarations, and in the previous one of these discussions I outlined the various areas where they had decided not to continue or to set a sunset date for their declaration activities, and that's due to the fact the competition was sufficient to remove the ACCC's role. They also did a public inquiry into declaration of domestic mobile terminating access service, and they decided they will extend the declaration on this particular service to 30 June 2029 with no variations. And this is, it's essential service to telecommunications that allows consumers to call people that are subscribed to different mobile networks. So they don't believe that there's sufficient competition in the way the market operates for their oversight to be removed. They also decided not to regulate the application to person SMS service at this point, but will continue to closely monitor movements in that area. So that's an area that they're saying, well, we think the competition's probably okay, so we're going to take our focus away from that market. in terms of regulating it, but they're going to keep a close eye on it. And they've also commenced 3 final access determination inquiries to consider the terms and conditions of access for the 7 services that remain declared. And so there's a number that still remain declared. As I said before, some have sunset clauses, so they won't be declared forever. But the three of those, domestic transmission capacity service, voice interconnection services, and resale fixed line services, or the copper networks. Then the broadband measuring report was put out, and this is quite interesting, I thought, because it talked about the fibre to the node and hybrid fibre coaxial connections and the level of outages, and sort of saying that those particular connections are likely to have more frequent outages than those with the fibre to the premises connections. And they showed that the FTTN, so to the node, accounted for almost half, 48% of the services experienced an outage on most days, and despite representing 34% of all NBN fixed line connections to the Measuring Broadband Australia program. So it's fairly high, really, when you think about it. And then the fibre to the premises represent 36% of the connections in the program, accounted for only 12% of outages. So obviously much more reliable services if you're going to the premises as opposed to the node. And then they also looked at latency and packet loss. And what does that mean? Well, latency refers to the time it takes to send data from the user's device to a server and back, so that the round trip. And packet loss is when a user does not receive all the data that they requested when using online application. So they sort a packet of information and they're not getting the full amount of information back. So the average latency of NBN fixed line connections was 10.7 milliseconds, and the average packet loss was 0.16%. So both of those are pretty low numbers, so not things ACCC is overly concerned about. The electricity, and again they do these regular reports, and they found that the median effective prices for residential electricity across all regions grew by 14%. So that's concerning over that 12-month period. But having said that, even though the amounts are going up, it was largely offset by the fact that we had one of the warmest winters on record in 2023. That was early on, I think. It's been much colder recently, I think. But anyway, so even though the price is going up, people weren't having to use as much electricity to heat their homes, and so the prices in net terms hadn't gone up. The lower usage meant that household electricity price remained relatively steady, rising about 1%, and small businesses decreased by 9%. Now, from September 22 to 2023, 18% increase in the number of consumers applying for financial hardship from the electricity retailer. There's also a number of basic support plans by various governments to help people with electricity bills. Customers are increasingly being moved from flat rate plans where usage charges are the same at all times of the day to time of use plans or demand plans. So people are becoming a bit more sophisticated with the type of plans they get. Embedded networks are private networks that allow a single seller to provide essential services such as electricity to multiple occupants of a single site. So here you're talking about high-rise apartments or office blocks, which there's a sole account, and they basically bill the occupants individually for the electricity provided, and they're concerned about these embedded networks because they believe there's a growing number of embedded network customers who do not have access to the same level of competition or choice of electricity providers as a freestanding homeowner does, but also the less transparency in that market. The first other was the Virgin Air New Zealand code share, and this is an authorisation which allows a unilateral code sharing agreement between these two airlines. And effectively what it means is Virgin can place an airline code on Trans-Tasman routes operated by New Zealand. So it can say VA going to New Zealand, but it's actually a New Zealand plane. So that's really all it is. And the key thing here is code share rights provide the condition that New Zealand specifies the fares which Virgin Australia may market and resupply these itineraries. So it's effectively Air New Zealand deciding what the price is. So it's to ameliorate any concerns about price fixing there. And the final thing was Tyre's Product Stewardship Code, which has been around for a long time, 2013, and it's a scheme that was introduced by a number of tyre manufacturers to allow the number of tyres in Australia to be collected and recycled, and then to use the elements of the tyres for environmentally appropriate uses, not just in Australia but overseas. So as I said, it was first authorised in 2013, and as a result of this code, the Tyre Stewardship Australia collects levies from participating tyre importers and retailers and has directed 9 million of that funding to various projects. And basically what's happened is it's coming up for extension, and so the ACCC has granted interim approval while it seeks submissions from the market as to whether this should continue, and they're proposing to increase it for further 3 years. The question here is it's totally voluntary, so the risks here are much lower than you would generally be concerned about in terms of price fixing or something like that. But whether a system like this should be actually made mandatory by the government, I'm not too sure, because there are a lot of players in the market who aren't participating in this thing, which undermines the whole environmental benefits arising from this tyre product stewardship system. There's a bit of final commentary. I think Delta case confirms that when you're looking at penalty and the 3 times the benefit criteria, you have to look at revenue, not profits. So that's the big change, I think, and one that I think if people are being entirely forthright, they'd have to say, well, people thought it was profit. Now it's clearly based on High Court decision. It's all about the revenue. So that's going to make that calculation easier to do, and also going to result in some bigger penalties. Now, I think Delta also supports the view that when you don't have a compliance program and you get in trouble, and then you quickly implement a comprehensive compliance program after the breach, before the penalty, it will have an impact on reducing the penalty. Now, there are a few provisos around that, but clearly you've got to do it comprehensively, right? But then you've got to put the evidence to the court. It's no point just telling the court, we're going to do this or we did this. You've got to put it on. I think the best way is to ask your compliance professional, like in the case with Delta, me. I was asked by the company, actually offered to the company to put the evidence on for the penalty hearing, so the judge would have it straight from the horse's mouth, so to speak, as to what had been done. I actually put in all my training materials as well, so you could see specifically what had been provided in terms of training. And I think as a consequence of that, he put significant weight on how comprehensive the compliance program that was implemented by Delta had been. And he notes in his judgment that had an impact in the penalty, obviously reduced his concern for a bigger penalty to achieve both specific and general deterrence, specifically deterrence primarily. The chances of this company doing this again were reduced significantly due to having a comprehensive compliance program. Now, I should mention there, I do know that they have appealed. Delta has appealed the case, and they're appealing on the liability issue. I think they're appealing very much on the penalty, but clearly they don't think the case got over the threshold for an attempt to induce price fix. So it'll be interesting to see what happens there. It's very noticeable that ACCC is raising a lot of concerns about mergers. A lot are being resolved, and I think the interesting thing about ACCC and merger control is people have been saying, oh, divestiture is a stupid remedy, you don't need that for a breach of Section 46. But when you think about it, divestiture is a very common remedy in Australia in the context of mergers. And many mergers let through on the condition that they divest assets, and that's because if they didn't divest the assets, they'd have market power. So the way to ameliorate somebody having market power is to force them to sell some assets. And it seems to stand to reason in terms of misuse of market power, that if someone's proven to have market power, we want to achieve the same outcome. We want to force them to sell some assets to remove their market power. So I don't quite understand the government and various groups saying divestiture is sort of this wacky remedy that nobody used around the world. We use it all the time in Australia in the context of Section 50 to achieve exactly the same outcome. There, in Section 50, preventing somebody acquiring market power, the ability to set prices irrespective of the market. Why not do it in breach of Section 46, where somebody has achieved market power and we want to remove that from them? So anyway, it's not that wacky. It's not really that wacky at all. Finally, the Chemist Warehouse Sigma merger. There's been a lot of hullabaloo about it, and the ACCC's media release sounds like a real problem. There's going to be lots of issues there, but when you really delve down into those issues, they just don't seem to be sufficient to oppose the merger. Companies aren't going to discriminate unless there's a rational reason to do so, and I don't think there really is. It's sort of the basis that Chemist Warehouse is being described as an amorphous company that has an interest in competing and winning all the share of the market, and effectively there'll be a preferential treatment to Chemist Warehouse stores as opposed to Sigma aligned banner groups. The thing that's key there is that all these pharmacies are owned independently. They're not owned by the Chemist Warehouse entity that's doing the reverse takeover. They're not owned by Sigma. They're all owned by separate businesses. So the economic incentives to try and discriminate just aren't there. Furthermore, the merger seems to be catering to different markets. You've got your big Chemist Warehouse stores, which are largely destination stores, big range, and then you've got your other banner groups, which are more convenience based. So I just don't really see there's an interest in the combined entity from preferring the big bulk discount end of the market and the smaller, more niche type providers. There seem to be coexisting in the market, serving different groups, and why you'd want to preference one over the other, I don't understand. So I guess I'm just saying that I think it's going to go through with probably no conditions. Maybe the ACCC required the divestiture of a banner group, maybe the AMCO banner group, but even that I don't think is really necessary from a competition perspective. That's all I had for this month. It wasn't the busiest month of all times, but you can see definite trends arising. ACCC's really doing pretty sophisticated merger analysis, very clearly identifying their concerns, but expressing a lot of concerns about a lot of mergers. So that's all I have for this month. And if you have any questions, feel free to give us a call or send me an email. Bye-bye.